The case that is now being made, again, is that everything in America that we don't like is due to the systemic racism of the United States and is a data point in favor of the idea that America is systemically racist. The latest case that's being used on this basis, of course, is the Derek Chauvin case. This is why you see Van Jones making the case that if there is no conviction, it is open season for cops. Van Jones says that if we don't convict Derek Chauvin, then cops will be able to get away with murder in broad daylight. No, that is not what that means. That is not what that means. You see Jonathan Capehart saying the exact same thing. Jonathan Capehart of the Washington Post. Here he is making the case that he is ready for not guilty because America is racist, not because of the details of the case. We don't need the details of the case. That's irrelevant. He's ready for not guilty because of America's history. Everything is just evidence of American racism.
I am already prepared for a not guilty verdict. And I hesitate to say that, but just given the history of this country and the history of these situations, I have to intellectually and emotionally prepare myself for that.
Okay, meanwhile, Chelsea Handler, again, another member of the left, she says we shouldn't even have trials in cases like this one. Right? The narrative is so strong, you don't even need a trial. Due process goes away. So Chelsea Handler, genius that she is, she tweeted out, so pathetic that there is a trial to prove that Derek Chauvin killed George Floyd when there is video of him doing so. Oh, that makes sense. We shouldn't have trials anymore. No more due process. We'll just go straight to the conviction. Because after all, who needs due process when you have the narrative? Now, here's the reality, as I've been mentioning about this case. This is a heavy lift for prosecution. And this is not an easy case for the prosecution. And she doubled down on that, by the way. She said, perhaps we skip trials when there's audio and video footage of the murder. But there are several issues that still have to be adjudicated here. Okay, so for example, the prosecution has to show beyond a reasonable doubt, not by preponderance of the evidence, beyond a reasonable doubt, that Floyd's death was caused by Derek Chauvin's actions. But the autopsy report shows that Floyd was high on fentanyl and meth at the time and had a serious heart problem, and shows that Chauvin's neck hold didn't, in fact, cause damage to Floyd's trachea, which means he didn't damage his airway. Which means that while Chauvin's neck restraint could have contributed to Floyd's death by ratcheting up his blood pressure, for example, it's uncertain that it caused Floyd's death more than, say, the arrest in the first place, the excited delirium that Floyd was pretty obviously in before he was even on the ground. That's before you even get to the charges, right? That's just the basic causation issue. In order to charge him with manslaughter or murder, you have to show that his actions led to Floyd's death. Okay, and it can't just be but-for causation, right? But for Chauvin being there doing that, he would have lived. It has to be that his actions actually caused the death. There's a pretty strong medical case that may not, in fact, be the case. In a second, I'm going to explain the actual charges. Okay, again, the narrative here is that America is racist, that anything that we don't like is due to American racism, and this is just another example of that. Okay, but there are very specific questions that are asked in court on these sorts of issues. So let's talk about the charges for a moment. There are 3 charges that are being brought against Derek Chauvin. 1, second-degree murder. 2, third-degree murder. And 3, second-degree manslaughter. Second-degree murder is a fairly heavy lift. It requires that the prosecution prove beyond a reasonable doubt that Chauvin unintentionally killed Floyd while intentionally committing a felony. So the question is, did he intentionally commit a felony? Did he believe that he was committing felony assault on George Floyd when he was holding him in a Minneapolis Police Department-approved neck hold, by the way, for 8 minutes and 46 seconds, while a crowd of onlookers was yelling at him? Now, again, it's not just, do you believe that that's true or not? The question is, do you believe it beyond a reasonable doubt? Reasonable doubt is a very high standard of proof. So a jury could easily find that this is not beyond a reasonable doubt. Felony assault requires intentional infliction of bodily harm, that Chauvin wanted to hurt Floyd, not just use a suppression tactic that's already been greenlit by the Minneapolis Police Department. Is there evidence that he actively wanted to hurt Floyd there? Or is there evidence that he was negligent? Okay, we'll get to negligence in a second, because that brings us to the manslaughter case. Third-degree murder, depraved heart murder, that one doesn't really seem to hold, because depraved heart murder, the legal definition, requires that you acted in a way, quote, eminently dangerous to others plural. So usually depraved heart murder is a drug dealer distributing drugs that are tainted in some way such that they will kill people. And you distribute them to a number of people, and you know somebody's going to die. You didn't have specific intent to kill one direct person, but you knew that there was a good shot that somebody was going to die. You fire a gun into a crowd. You drop a brick off a freeway overpass onto the cars below, right? That sort of stuff is depraved heart murder. This has a specific alleged victim, and that means that you are really not looking at a depraved heart murder. So third degree really shouldn't even apply. In fact, a higher court at one point had thrown, actually, the trial court originally threw out the third-degree murder charge, and then it was reinstated by a higher court. And finally, there's second-degree manslaughter. And this is the one that it is most likely that Chauvin is convicted on. But if he's convicted of manslaughter and not of murder, do you think Jonathan Capehart is going to reevaluate his belief in the racism of the American system? By the way, even if Chauvin is convicted, do you think Jonathan Capehart and Van Jones are going to reevaluate their beliefs about the racism of the American system? Of course not. Because it is a premise that must never be challenged, the racism of the American system. Because so long as there is disparate outcome, it must be the system. And here's the thing. There will always be disparate outcomes so long as people make disparate actions. And so that second-degree manslaughter charge in the Chauvin case, it requires the prosecution prove that Chauvin acted with gross negligence. But gross negligence would have to show that Chauvin should have known his behavior might cause Floyd's death. Okay, and that's a hard case to prove. Why would he think that would cause Floyd's death, to put him in a neck hold? That is a basic suppression hold, again, approved by the Minneapolis Police Department. You have to prove that he intended to do that at the very least, he was negligent in that he knew that what he was doing could cause somebody's death. Well, barring Floyd's underlying conditions, that really shouldn't cause your death, right? If you don't have a serious cardiopulmonary issue to begin with, plus meth in your blood, plus fentanyl in your blood, makes it real difficult. So here's the thing. Chauvin could easily be convicted. There is certainly a case for Chauvin to be convicted on second-degree manslaughter lines. Andy McCarthy has made that case over at National Review. But if he is acquitted, that's not because of the racism of the American system. That's because due process of law requires a very strong showing of evidence and proof. But all the media are going to show is all the inflammatory stuff from the trial. The media are going to pretend like any defense of Derek Chauvin by his own defense team is somehow racist in and of itself. All they're going to show is the witnesses to what was obviously a tragedy at the very least, speaking emotionally about the issue. So, for example, one of the witnesses yesterday called the cops animals on the stand, which raised an objection. Here's what that sounded like.
When you were watching this interaction between these four Minneapolis police officers and Mr. Floyd, were you watching a cage match at the time?
Well, I only seen two of them, the animals. So I was watching more of a humane show.
Okay.
Objection. What's his name?
And
sorry about what you said.
That's okay.
Okay.
Okay, and he suggested that he was watching a humane bleep show. And he said, I was not watching a sport. Okay, all this sort of testimony is provocative, but it really is not probative. Probative means it doesn't actually contribute to whether there's guilt here or not, right? It doesn't go to the underlying fact pattern. But most of the testimony that's going to be shown on late night TV and throughout the day on your 24-hour news networks is going to be the witnesses saying that they stayed up nights, for example. That was what one of the witnesses said yesterday.
It's been nights. I stayed up apologizing and apologizing to George Floyd for not doing more and not physically interacting and not saving his life. But it's like, it's not what I should have done. It's what he should have done.
Okay, so, obviously this sort of stuff, it would be heart-wrenching. It would be terrifying. It would be terrible. But that doesn't go to the probative value here. But what you're going to see is the most evocative, emotional testimony. You're not going to see any of the underlying fact pattern presented on national TV, because that might actually undercut the narrative that this is a straightforward case with an easy solution. Facts don't care about your feelings, and it's a fact that The Ben Shapiro Show is the largest conservative podcast in the nation. Be sure to hit the subscribe button to stay up to date on all of our content.